Mediation plays a key role in many child custody cases. Parents may disagree about custody arrangements, visitation schedules, decision-making authority, schooling, healthcare, and countless other issues affecting their children. While litigation is sometimes necessary, many custody disputes in Tahlequah and throughout Cherokee County are resolved through mediation rather than a trial. Mediation is designed to help parents reach agreements without placing every decision in the hands of a judge. What is custody mediation? Mediation is a structured process in which a neutral third party, known as a mediator, helps parents discuss disputed issues and work toward a mutually acceptable agreement. Unlike a judge, the mediator does not decide the case or impose a solution. Instead, the mediator facilitates discussions and helps the parties explore possible resolutions. The process is generally confidential, allowing parents to speak openly about concerns, parenting schedules, and proposed solutions without fear that the discussions will later be used against them in court. Why courts encourage mediation? Tahlequah courts recognize that parents are usually better positioned than a judge to create a parenting plan that fits their family's unique needs. A judge may spend only a few hours hearing evidence before making custody decisions. Parents, on the other hand, understand their children's schedules, educational needs, extracurricular activities, medical concerns, and family dynamics. Because of this, Oklahoma courts frequently encourage mediation to give parents greater control over the outcome of their case. In many custody disputes, mediation is required before a contested hearing will be scheduled. Issues commonly addressed in mediation. Custody mediation can address a wide variety of parenting issues. Parents often use mediation to discuss physical custody arrangements, visitation schedules, holiday schedules, transportation responsibilities, communication guidelines, educational decisions, extracurricular activities, and child support-related concerns. The more detailed the agreement, the less likely the parents will be to return to court over the same issues. Mediation can reduce conflict. One of the greatest benefits of mediation is its ability to reduce conflict. Children are often negatively affected when parents engage in prolonged litigation and constant disputes. By focusing on problem solving rather than winning or losing, parents can often develop healthier co-parenting relationships going forward. Even when complete agreement is not reached, mediation can narrow the issues that must ultimately be decided by the court. Mediation may save time and money. Custody litigation can become expensive and time-consuming. Mediation frequently resolves disputes more quickly and at a lower cost than full-scale litigation. Parents who successfully reach agreements through mediation often avoid months of additional court proceedings and legal expenses. For many families, this allows resources to be directed toward the children rather than continued litigation. Agreements reached in mediation can become court orders when parents successfully resolve issues through mediation. The agreement is typically reduced to writing and submitted to the court for approval. Once approved by the judge, the mediated agreement generally becomes part of a legally enforceable court order. This means both parents are required to comply with its terms just as they would any other custody order entered by the court. If one parent later violates the agreement, enforcement remedies may be available through the court system. Because custody decisions can shape a child's future, obtaining experienced legal guidance before and during mediation can help ensure that any agreement reached is both fair and in the child's best interests.